Of order.
Bill is rejected.
Rejected. Highly appeal.
May I please, your Lordship?
Hmm.
Lordship, I beg to mention item number 14. Lordship, we have filed an additional affidavit in this case. Lordship, let me be put up with the record. Lordship.
Okay.
May I please, Your Lordship, I beg to mention an urgent listing of a bail application, Lordship. Lordship, the petitioner is a 70-year-old. Lordship, the matter is of previous heard. Lordship, matter may be come up on 28th, Lordship, of this month.
28.
Lordship.
May I please, your Lordship? Lordship, I beg to mention an IA for listing in orders column matter may be listed next week, Lord.
IA relating to what?
It is related to correction of an typographical error passed before this honorable court.
Bail petition.
Typographical error, criminal petition.
We'll have to mention before previous weekend.
May it please, Your Lordship, I beg to mention item number 5. The matter may be adjourned for the day, Lordship.
Counsel for the petitioner has paid for adjournment. List the matter on.
All Lordship.
May I please, your Lordship? I beg to mention item number 21 from the daily list. Perhaps in the sitting of the signature, I didn't quite.
CD is called for is not received. Issue reminder. List the matter on.
On 23rd May.
Interim order.
Date order shall remain in force till then.
Interim order continued. Highly appeal.
Item 1.
May I, my lord, this application under section my lord 483.
Hmm.
Now he's in custody, my lord, for about 35 days as on date, my lord.
Hmm.
Now lordship will find, my lord, appear at page 8, my lord.
Page 8.
Page 8.
Yes. Will
Now,
you the
Lordship.
CD rape case?
Now lordship kindly see the statement
Hmm.
of the my lord victim has been recorded, my lord.
Hmm.
As
Sashil,
10, my lord.
please read.
My lord, if your Lordship only one thing remembers that other day I did that shown arrest case in respect of 3 persons that from while coming.
I cannot
my lord.
remember.
Okay, then your Lordship will carry it, my lord. My lord, the affair is on, my lord, your Lordship, see the date, my lord, on 10th. With due regards to the subject cited above, my bike was stolen on last night about around so-and-so from Mathura Nagar, house number so-and-so, Heritage Apartment. I parked my bike near Shipa Apartment, an apartment CCTV installed there and they record everything. Kindly do the needful for which I will be grateful. My lord, would your Lordship be pleased to see the bike number, my lord?
Bike number, yes.
5648.
Hmm.
Now, my lord, your Lordship may come to page 13.
Page 30, yes.
Yes, my lord. My lord got it.
Yeah.
My lord, the second bike is the same one, my lord. Seized, seized, recovered. My lord, see the person signature from whom seized, my lord.
Golme.
Gulme.
Yes,
That
now
is,
I remember. Okay.
yeah, that is recovered on 14. But we were, my lord, we were apprehended on 15th while coming from Manipur. And my lord, this was recovered from
Golme.
Karbi Anglong, yes, Gulme. And that in the forwarding, it is clearly written, that is in page 19. Would your Lordship be pleased to see page 19, my lord?
Nah, it's okay.
Hmm.
She's from, it's not required.
Yes, my lord.
Hmm.
No, in the forwarding, it is clearly written that from
She's
Gulme,
from Golme.
yeah, on 14. So, my lord, it is already 3032. It is 3 years, but we are already behind for 40 days, my lord.
Yes, yes.
Yes, Lordship.
You have, we need the CD, I think.
Lordship. What
You
about
have the CD?
Lordship?
No.
No, she didn't.
My lord, possibly, if I may say, my lord, already recovered and this person are not connected and already more
Have
than,
you moved the lower court?
yes, yes.
Rejected, Lord.
So, short date for
Short.
CD, because bike theft is, if you remember, there was this case, Honorable Supreme Court had taken up that relating to ailment,
Right.
that bike thieves were not given furlough. Bike thieves and car thieves, they were not given furlough. Everybody were sent out of the jail, but not bike thieves and car thieves.
No, only thing over here, my lord, if your lordship looks at the annexure, I'll just satisfy, my lord, only one thing. If
Oh,
you're,
you give me a short.
yeah, I understand, my
very
lord.
short
I
time.
understand, but only thing is that, my lord, where I am not connected, that is the reason I'm
No,
showing.
you forwarded
Lordship,
me-
I
Page-
only wanted
name
to
is
point out
mentioned.
one thing, Lordship. In forwarding, there is stated that as a whole, total 7 stolen bikes were recovered as per information given and led by the apprehended accused in the forwarding, Lordship.
So that is by Gulmai.
That
On
is-
the other day, I showed one of 5 and these 2, my lord, 7. And my lord, page
The
70.
other day, this same case had
Yes,
come up.
in that case, I was shown arrest. If your lordship remembers that your lordship wanted from which date I was shown arrest.
So did I call for the?
Yes, on
CD?
30th, on 30th.
We'll call for the CD then.
But
Call for
only
the
thing,
CD, list
only
the-
thing I wanted to show your lordship, the page 17 once. 17. The why I have been apprehended.
Okay. Yes.
Well, these are the 4 persons.
Mm.
Number 1 is the driver.
Mm.
And rest 3 are we, my lord, conductor and 2 helpers.
Mm.
And over here it is on 15th. The bike was stolen on 10th, recovered on 14th from Gulme. And this is seized on 15th while we were coming from Manipur at Jorabat. And this is 4 lakhs rupees.
Mm.
Nothing to do with bike. We have been just pushed to that case, my lord. And my lord, if your lordship looks at another thing, see the date and time of seizure.
Mm.
My lord, I would only say that this amount would have vanished because of that filming at that time could not be vanished because we were apprehended at 8 o'clock in the morning. The seizure was at 12, after 12 at night, my lord. So your lordship would understand that during that period, that money was in a volatile situation, whether to be seized or not to be seized. Only when a businessman gave a call that I gave the money to the driver for giving it to one man in Guwahati and take the goods. That is the reason that seize had to be made, my lord.
Short date may be fixed, Lord.
But I think, my lord, more than 40 days, I think your lordship will appreciate, my lord. Everything is recovered, nothing is there, and
Yeah.
interrogation is also over because they have taken police remand for 2 days. 15th, I was arrested. They asked for police remand. On 17th, I was.
30th is next week, I think, first. 30th same, then we'll take up the case of that same accused persons in that case.
Okay.
As it is, there's no point, you see. If I give them bail, they are still behind bars in connection with that case. So they won't be released. So we'll take both the matters together.
Yes, sir.
Call for a CD, list the matter on.
30th.
Item 6.
May I please, your lordship?
Mm.
Here is a case, my lord, what happens, a 17 years old girl, she eloped with the,
Applied bail earlier,
Lordship?
applied for bail earlier.
No, no,
You have not applied.
no. This is for the first time, your lordship.
Okay.
It is arising out of a land dispute, your lordship. It's not that we have assaulted you, lordship. Actually,
So
what
in
happened?
that grievous injury,
Grievous injury.
on
until-
head, now that person has died.
I
I'm
have
really
derived-
grateful.
As,
that
as
you-
per
you are
information
very,
derived, as per information derived. But here,
No, but you're not concealing. I'm really grateful to you. You're not concealing. You're
lordship,
honestly submitting.
lordship,
So let us call for the CD.
lordship wife maybe, lordship wife.
That's what I told, no, that wife was more involved yesterday. I thought she is a woman. She may not be so aggressive. Then I came to know later through the CD.
But you
After
lordship,
granting her bail,
Lordship,
Absolute, making
uh,
it
lo- lo-
absolute.
but Lordship is aware of the facts, cracks of the case is that they arising out of a land
Yeah,
dispute.
true.
Some other places the dispute happened, Your
Sometimes it
Lordship.
happens that.
And ultimately, two sides, some
you
alterations
you
are there.
cannot suppose that the woman will not,
So, Lordship,
that-
how you could be, Your Lordship? Because they are armed with, supposing that they are armed with lethal weapons, Your Lordship. Went to some other places, in the distant places, wife was maybe conversant with Your Lordship, but wife is not practically present out there, Your Lordship. So
no,
therefore,
but in the FIR, she's named that she went there.
FIR is not Your Lordship. Bringing the name of the wife is not Your Lordship, Your Lordship.
No.
The Lordship, you are in the high pedestal, Your Lordship might take it. My Lordship, aware of the facts, because the allegation may be in various, Your Lordship. But Your Lordship,
No. Person has died.
but
and
Your Lordship, I
there is direct
suppose,
allegation in the FIR, not in the CD in the FIR.
but Your Lordship, to my understanding is, I suppose, Your Lordship, the wife
You
may
see,
not be,
head injuries are.
wife
see,
may
this-
not be
this
implicated, Your
injury
Lordship.
had occurred in the month of March and now he has died. These injuries are very dangerous.
Because
Head
Your Lord,
injuries-
5 persons are arrayed in this case, Your Lordship. I am only
No.
praying for the wife, Your Lordship. Then,
I told you, no, what happened.
then Your Lordship,
yesterday.
short date may kindly given.
Short-
A very short date.
Call for the CD along with the postmortem report of the victim, list the matter on. Medical legal report लिखी दिया. Postmortem नाला है.
So far the death of the husband of the informant is concerned, Your Lordship. I have heard, Your Lordship, derived the information
Yeah,
that I
and I'm
given,
really grateful.
and therefore, Your Lordship, I make the
I
submission.
appreciate your conduct really.
Deep obligation.
Also, in this case, also may please to call the CD, Lordship. This one Khetri police station.
Call for the CD, list the matter on.
Okay.
Wait, Your Lordship, Milord, case diary was called for in the matter, Milord.
It's not available.
We have not received the case diary.
Lordship.
Yes.
Milord, the fact of the case is, Milord, that
No,
one
you are
person,
supposed to bring some judgments, no?
we have some furnished the judgment.
Yes,
Lordship.
yes.
Let us start with let us see the order, Milord. The order does not specify any date of the entry production. May I read the order? Order is 11.
No, it's not specified.
It's not,
No, date has not been specified.
Lordship. So this should be the order in any interim bill application. That is my submission, first submission, Milord. Lordship, may kindly see first judgment 2010, 15 SSC 154, paragraph 3. First judgment,
That metric case is discussed.
Lordship.
Salahuddin and Matres case is discussed.
No, Lordship, that case is not been discussed here.
Ah.
Just very
But
small
you said
paragraph.
There's a limited time that those cases.
No,
are
there are
discussed.
two ways of granting an interim bail, Milord. One, if he is a convict, and one, if the charge sheet has not been filed or he has not been conviction, Milord. So if he is not a convict, Milord, the normal rule is that bail should be granted. If the interim bail is granted, it should be granted till production of the case diary. Once the case diary is produced, Lordship may cancel the bail application. But till then, the bail should be there, Milord. That is what it
Which
is.
paragraph?
Paragraph 3, Lordship.
Mukesh Krishnapuria,
Lordship,
2010.
2010, Lordship.
Okay, paragraph.
Paragraph 3, page 150, second page, Milord. We have flag mark it, Lordship. Lordship. Lordship has his, Milord.
Paragraph 3.
3 years.
Yes.
However, the prisoner may apply for regular bail before the court concerned. Along with the state application, he may file an application for interim bail pending disposal of the regular bail application. We have made it clear on a number of occasions that the power to grant regular bail includes the power to grant interim bail pending disposal of the regular bail application. So till disposal, Milord, that is the power is inherent in the power to grant bail, particularly in view of Article 21 of the Constitution of India. We are of the opinion that in view of Article 21 of the Constitution, a person should not be compelled to go to jail if he can establish prima facie that in the facts of the case he is innocent. There is a presumption of innocence, Milord, because charge sheet has also not been filed in my case.
No, but here you have appeared, you have asked for interim bail because you are to appear for
Yes,
exam
that's
or
what-
you are not well, something
Yes.
like that.
I was not well. I was a boy of 21 years of age, Milord, and
So
the
this is
exam.
not prima facie case that you are innocent.
Lordship,
This is not prima facie case that you are innocent.
there is a presumption in my favor, Milord, that I am innocent, Milord. That presumption holds, Milord. Now, second judgment, Milord, what happened earlier cases, Milord, that in 439, while granting interim bail, the person was,
Second case, which one?
Milord, is 2006, 9 SCC, very one page judgment.
Yes. Which?
May I just explain, my lord, the one factor with the matter? What was earlier?
You can read the judgment.
Lord.
It's only 4 paragraphs.
Yes, yes, Lordship. This appeal is directed against the order of the High Court passed on so and so, rejecting the bail application filed by the applicant under section 439 CRPC, mainly on the question of non-maintainability of the application. According to the High Court, the petition under 439 CRPC is not meant as the petitioner was not in custody. Here, interim bail was granted. What the Supreme Court held? From the bail application filed on ITNA by the appellant under section 438, it clearly appears that on the day the appellant was in custody as he was on interim bail for 15 days from so and so, and his application could have been considered on merit instead of dismissing the same on the ground of non-maintainability. In
But
view
he
of
was on interim bail for 15 days. The time
Lordship,
period has been mentioned here.
here, time period was mentioned. Then also the Supreme Court says that
This
instead
will
of
not work in your favor. Here, time period has been mentioned.
here, time period has been mentioned. my lord.
Ah.
No, I am
Even the first judgment also is not in your favor.
the first judgment. I hope so, my lord. The question here is, my lord.
Yeah, we'll go to the other judgment.
Yes, yes.
Of course.
No, the second judgment, my lord, let me explain, Lordship, if I may. The second judgment basically says, my lord, that earlier, for maintaining an application, the 439, one has to be in custody. Because of this fact, in some cases, the accused was earlier directed to be present before, to surrender before the CGF or the police, my lord. This judgment says, my lord, that that is not a mandatory condition of granting a bail.
Yes,
Now, the
because
third.
he was given a period of 15 days.
He has given a period of 15 days. Then also the court says that even if he is not in custody, the court should take into consideration the case that is before the bail application. That is the second judgment.
I don't think this is working in your favor. All right.
Lordship, that's Lordship discretion, my lord.
Yeah.
I will not
Yes.
say on that, my lord. Now, the third judgment, my lord, it says, my lord, the discretion exercised by a single judge, my lord, cannot.
2024.
Lordship 2024 to SSC, the discretion exercised by a coordinate bench cannot be interfered by another coordinate bench. my lord. This is page 11, my lord. Paragraph 23, if you love to say.
We definitely respect the orders of court. and-
Lordship cannot even interfere with that order.
No, of course, why should I? Why will I
Lordship.
interfere?
That is there. my lord. If Lordship will not interfere, then the
So,
order remains.
It was your duty to surrender. That is what I was saying. I am not about to interfere.
Lordship. No, my lord, I
So
prefer
we
with your
will
Lordship
definitely
only.
need the CD.
Definitely. leave the
Moreover,
CD,
let's
my
say,
lord.
if I, in page number 19 and 20,
Hmm.
against this petitioner, he is the prime accused. Moreover, the vehicle used in the commission of the crime, Lordship, he is the owner. Thirdly, Lordship, he is the Lordship, the
No,
one
we
snatch
the
mobile.
CD,
is
that
also-
is true,
That is
ma'am,
why,
we
Lordship,
just-
we are
And
against him.
see, it is, Lord.
Actually, that time period ought to have been mentioned here.
No, my lord, I
Time period
disagree
has
with
been
your
mentioned.
Lordship on this, my lord, because Lordship has seen earlier or the first judgment of the Supreme Court said interim bail till disposal of the bail application. That should be the rule, my lord. Because once Lordship grants me an interim protection, then Lordship again, without considering the case that when the presumption of innocence is in my favor, asking me to surrender, my lord, and taking away my right of liberty would be, my lord, not fair. my lord. My humble submission would be that. Well, what happened here? 19-year-old boy on the basis of suspicion picked up, shot at a student of a college without a trial, and the CD is not produced before 4 days, my lord.
One last chance may be given, Lord.
No, this doesn't imply that. Both the judgments does not imply that time period. If we are given a time period, then you must surrender before the court.
Yes, a time period is there, my
But
lord.
here time
Now,
period
the
was not
discretion is,
given,
the-
maybe
yes.
that's a typographical error.
No, my
What
lord,
I-
I disagree with the submission.
What
I
I
made the
could-
submission in the court.
I could figure out, this is a typographical
Lordship
error.
then refer it to the
Easily
dead
figure
bench, my
out.
lord.
I can easily figure out, it's a
No,
typographical
if
error.
that is your
It
lordship,
happens with me also.
Lordship may kindly see the last judgment, how a judgment has to be interpreted, my lord, of a court. This judgment says, my lord,
Which one?
but page 11, Lordship has seen where coordinate bench cannot comment upon the discussion.
Of course not, of course not.
Is Lordship, the fourth judgment.
Definitely.
Then the fourth
Of course
judgment, Lordship,
not.
last one.
We must always respect the judgment
Yes,
of a
Lordship.
coordinate bench.
That has to, because on what basis Lordship passed the judgment, only Lordship can understand that, my lord. If your Lordship judgment is in the same facts, my lord, another court cannot.
Uh, practice, this is practice and procedure. Throughout the ages, we've been practicing and proceeding in the same manner. That the time period is
Not-
given, you surrender before the court,
And that,
and then again you apply for bail, your bail
yes,
will be
Lordship,
considered.
that can be also one practice, that can be also one
This is
practice.
general practice.
Again,
And that is why I'm.
in many cases,
I'm
Lordship,
certain that this is a typographical error. And it happens in my
because when the
dictations
submission
also.
was
It
made, the court
happens.
was of the view.
Sometimes we miss a point and then
Where
it
submission,
doesn't get tied.
when submission was made before the learned single bench lot, the court was of the view that the bail should be granted. The PP said, let the case that be produced, interim bail, let the case that be
The
produced.
story, I'll call for the CD and then we will extend the interim bail.
Lordship.
CD as called for is not received, we should reminder, list the matter on. Interim order shall remain in force till then.
Lordship, I'm on that.
May it please the court. My lord, in this matter, the evidence of the victim is to be recorded today in the court below. So I pray that 2-3 days after this matter may be fixed. ma'am.
Learned counsel for the petitioner has prayed for adjournment. We have the LCR, no?
It
List the
is-
matter on,
My lord.
Can go.
list the matter on. 8 of May is
My
today.
lord, I'll leave next week, my lord,
Next
because
week.
today date is fixed. 2nd of May. Public.
May I please, your lordship? Lordship, it is a regular bail application. Accused is behind the bars from last 46 days. FIR is in page 12.
CD is not available.
You're behind bars for how many days?
46.
46 days. 103. Let us wait for the CD. CD has called for is not received, with a reminder to forward the CD along with the PM report, list the matter on 6 May. Mm,
Please, your lordship. Lordship, we have mentioned about the additional affidavit, lordship.
yes, yes.
The lordship may take up the matter after some time, lordship.
I plead, Your Honor. Your Honor, the English counsel has his legs at another podium.
Okay,
Your
okay.
Honor. Kindly timing the
Right.
matter.
Item 16.
May I please, lordship?
Mm,
Kindly pass over the matter for timing.
okay.
Item 17.
This is an application on a 482, my lord. What happened during pendency, my lord? Charge sheet was submitted. So then I made a prayer for my lord, calling the scan copy of the case diary. Accordingly, scan copy of the case diary was called for, my lord. So today is the date for my lord, hearing. My lord. FCR is here. So case was registered under lordship. May kindly see the
Are you
FIR.
ready? Have you gone to the scan copy?
Yes.
Okay, yes.
Lordship, FIR is at page 12, my lord, vernacular.
Mm.
Case is registered under section 1172, within bracket 2 and 74 BNS, my lord. 1172 is bailable and 74 earlier 354 IPC, my lord, that is non-bailable. Page 12, my lord.
I do want to read. Yes, please read. Learned Senior Counsel, Mr. H.R. Chaudhary, for the petitioner. First file is application on section 482 of the BNWS 2023 with prayer for pre-arrest bail, as is apprehending arrest in connection with so and so PS case under so and so sections. Mr. K.K. Das, learned additional PP Assam. it is submitted that a complaint case has been lodged, filed.
Yes, 14.
On 26/1/2025, i.e. after 6 months, when an FIR was lodged by the accused number 2, Maina Ray, R-A-Y, Ray, Maina Bala Ray, Maina Ray, alias Maina Bala Ray, MAYNA BALA RAY, Maina Ray, alias Maina Bala Ray, on 6/7/2024. Full stop. It is alleged through the instant complaint petition registered as FIR number
Yes, 19.
hyphen Goripur PS case number 39 of 2025 under section under section number by Madhavananda Roy against the present petitioner and accused number 2 Mainabala Roy Ray R-A-Y. It is further submitted that Madhavananda Roy has concealed his other name, that is
Joydev Roy.
Joydev Roy,
Yes, 30.
full stop. Joydev Roy is the accused number 1 in the earlier case, i.e. Goripur PS case number 230 of 2024. Full stop. The allegation in the present FIR unfolds that the present FIR stroke complaint petition unfolds that the accused number 2, Mainabala Roy, has lodged the false FIR registered as Goripur PS case number 230 by 2024 against the present complainant and his family members. Full stop. Bail was granted by this court to the complainant and his family members. Full stop. it is submitted that false allegations have been brought up against the petitioner. And then both the false allegations have been brought up against the informant litigant, petitioner, informant, Madhavananda Roy. And then both the petitioner number 1 and the accused number 2 demanded money, huge amount of money to weaken the case lost by the accused number 2, i.e. Goripur PS case number
230.
230 of 2024. Full stop. It is further submitted that the petitioner, with the help of his employee Ramananda Roy, tried committed the offense of extortion and the complainant was compelled to fulfill the illegal demands. Full stop. Money was demanded to mold the investigation of the aforementioned Goripur PS case number 230 of 2024. Full stop. The complainant had to meet the demands and pay rupees 11,20,000 through online UPI transaction and rupees 5,60,000 through cash. Full stop. It is submitted on behalf of the petitioner that Ramananda Roy is not the complainant's employee, but is his brother. Full stop.
Of the complaint.
Yes, that there is evidence of transaction, 16 lakh.
5 lakhs is there in Ramchandra
Uh,
from the Manavan.
Where?
To the Ramchandra,
Sa-
the brother of
Ramananda Roy.
Ramananda.
Ah.
It is there. Lordship.
Where?
It is admitted, my lord,
The flag mark, I have flag mark.
affidavit shown by the Ramanando, it is revealed paragraph 4 and 5.
Hmm?
I have furnished a copy of the affidavit, my lord,
Hmm.
shown by the Ramanando.
Hmm.
In paragraph 4 and 5, it is stated regarding transaction between the complainant and the Ramanando. And this amount was said, my lord, here solely in connection with internal family matter and nothing whatsoever to do with the accused so and so. And then 5, I have no financial dealings with Uttam Kumar Pradhani in any manner, nor I have ever received any amount from the complainant on behalf of the accused number 1, so and so, nor I ever made any payment to the said accused.
This whose account is this?
This Manavan, the complainant.
And
No, but this affidavit will not work. No, you have not submitted with the petition.
because, my lord, it was shown later. That is why we have not annexed with
So
the,
it won't work.
and yes,
Moreover,
Manavanda Roy has received, no? Yes. Bank account,
bank account.
SBI account number, Manavanda Roy.
And it is also, name is also there, Ramchandra. Ramchandra.
Ramanand.
By
Ramananda.
salary transfer. Ramanand, yes.
Yes.
5 lakhs.
But I am not Ramananda, my lord. I am Uttam Kumar Pradhani, my lord.
And
No
Uttam Kumar
transaction.
Also,
Ramananda is the accused number 1
No,
in
no.
the other case. No,
other-
Mohan Madhavananda.
Madhavendra is the complainant. Transaction
in
between
the FIR it is stated, Lordship.
uh,
FIR in the.
FIR itself also stated, my lord, the transaction was conducted between Madhavendra and Ramanandra.
Yes.
Both are own brother.
Mm.
As revealed from.
Yes, Ramananda
But
Roy.
there
Yes.
is, yes, there is no transaction between the accused and the complainant. my
As
lord.
per the FIR, Lordship, through Ramananda, his brother, that is Uttam took money, Lordship. It is the allegation.
It is,
But
it is their proof, 5 lakhs. But this is not cash. This is bank transaction.
Bank transaction, Lordship. That is
Yes.
why, otherwise,
In
why
the FI, it is mentioned cash.
cash also, Lordship, but it is there, Lordship, at various times, various amounts are given, Lordship. And moreover, otherwise, why he will give 5 lakhs, Lordship? They should have explained on this purpose he has given 5 lakhs, Lordship. They have not explained any reason, Lordship, why he has given the 5 lakhs rupees, the informant, Lordship. Moreover, some threatening was also given before this person to this person, some days before.
But from the FIR itself, my lord, it is revealed to no transaction between the accused and the complainant. No transaction is there.
But that FIR also reveals that there is a transaction between Ramananda and
Yes, but
and then Ramananda is his brother.
not my brother, brother of complainant, my lord, of the present case.
Yes.
But on Ramananda is not the accused. He is made as a witness in the complainant. I complaint.
There is the thing, no? That accused is getting the money. Pradhani is getting the money from Ramananda.
No.
Yes, it is in the.
This affidavit is shown by the Ramananda, no transaction between the accused and the Ramananda. Yes. No transaction, affidavit shown by the Ramananda. Paragraph 4 and 5 of the affidavit.
Lordship, it is in complainant page number, in para 7, Lordship.
Mm.
It is clearly said, the complainant begs to state that all the transactions were made through the employee of the accused number 1, namely Ramananda, which is on
Yes.
record.
And
It is
it
there,
was,
allegation is there, Lordship.
and it was admitted by the Ramananda in the affidavit also. Transaction was conducted between Ramananda and the complainant. But that transaction was conducted for family matters, internal family matters, paragraph 4 and 5 of the affidavit.
But this affidavit will not work. Internal family members maybe,
Yes.
but it has proved that both brothers are sending money. The payment is received by Ramananda and Ramananda is sending money to his brother.
Yes, it is admitted,
And the payment is made for.
not to the accused. No transaction with the accused. Transaction between complainant and Ramananda,
Mm.
not Uttam Kumar
Yes,
Pradhani.
complainant and Ramananda.
Yes, not with the
not
Asmata.
Uttam Kumar.
But
Yes,
Lordship, it is stated that the
not with the Asmata.
accused number
Paragraph
1 is,
7.
And it is true also.
accused
the
number 1
CD
is Uttam, Lordship.
Huh?
Accused number 1 is Uttam.
No, there is no transaction with Uttam,
Yes,
No, through Ramananda, Lordship.
only between brothers.
Through Ramananda.
Mm.
That the complainant begs to say
Then
all the
Ramananda is
made
paying the
through
money to his
employee.
brother.
Employee of this Lordship. This one is he used the Ramananda. As per this.
But it is not
FIR,
5,60,000, it is 5
Not-
lakhs only.
5 lakhs.
Mm.
The bail objection, it is also stated, Lordship. Lordship may go through.
No, it is there. There is he is taking money from Ramananda. And but he's saying that brothers are taking money from each other because their brothers are transacting with
Lordship.
each other but not with the accused number 1.
yes,
Because this is the FIR, they have the FIR, so they have brought this
yes.
internal transaction between brothers.
Not with us. Any condition, my lord,
Lordship may peruse it and pass the
since
order.
there is no, my
Appropriate
lord,
order
transaction
taken
between the
after order.
complainant and the accused, my lord. So, my
But
lord,
there is evidence.
my lord, any condition. my lord.
Transaction is there between the brothers.
Yes, between brothers, transaction is there.
Because he's Uttam, Uttam is taking money from the brother. So,
Ramanand,
yeah,
Ramananda is taking from his. But Ramananda shown affidavit, my lord, no transaction with me, my lord, between the accused and
Lordship,
the
informant sent
witness.
the money to Ramananda and as per the FIR, Lordship.
yes,
Ramananda give it to the Uttam, Lordship.
and it is there.
It is stated in the Lordship. The fact
It
is
is
that
there also. Informant send money to Ramananda.
if he used this Ramananda, he himself does not take the money.
And my lord, very
It is
interesting, my
allegation
lord.
is that only,
If
Lordship.
the transaction is conducted through Ramananda, my lord, but that Ramananda was made as witness, not as accused. And we make as accused, my lord. My lord, kindly come to page 14 and 15. On Ramananda is a witness, my lord.
Maybe, but this informant has been sending money to Ramananda.
Yes.
Debit, sending money, lakhs and lakhs of rupees. Why he'll keep on sending money to his brother so much?
That may be explained by the my lord complainant as well as the my lord
That
his
is what
brother
saying
Ramananda my
he
lord.
has to pay to Ramananda.
Ramananda will
debit 10
explain my
lakhs.
lord, but
Debit
how we can
20,000,
explain
debit,
my lord?
yes, 5,60,000, yes. Debit 20,000, debit 1 lakh, debit 50,000.
Attending is also developed.
And then this, their conduct is also not good. Their conduct is also not good. That case lost by Mayawala Day against the informant. He has a hand in the suicide of that person.
Yeah. Yeah. Discharging lordship in the guise of family dispute or land is like that also. But in that guise, they have done this type of things. Lord. Money is also taken in the name of family dispute.
I think can be granted, I think.
Nothing may taken
Can be granted. He will appear every time.
with my objection.
Yes. Learned additional PP has raised serious objections stating that there are incriminating materials in the case diary against the petitioners. The witnesses have stated that the witnesses have stated under section 161 CRPC that the petitioner has threatened them and compelled petitioners threatened the informant and compelled him to pay huge amount of money. I have also scrutinized the case diary. Full stop. Indeed, there are incriminating materials in the case diary against the petitioner. Full stop. Both the parties are embroiled in the dispute and FIRs have been lodged against each other. Full stop. Investigation has progressed substantially. Full stop. I have considered the submission that the petitioner is willing to abide by any stringent bail conditions if imposed upon him. Considering all aspects, petition is allowed. In the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority, under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 3, the petitioner shall not exercise threats to the witnesses or the complainant and maintain the peace. And 4, the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD.
God bless.
In this case, charge is submitted. Lord.
But petitioners are on the interim bail. Well,
Our learned counsel, Mr. Anuddin, for the petitioners. Third, learner additional PP Mr. KK Das, who has submitted that charge sheet has been laid against the petitioners being serious.
SP/25 dated 22/4/2025.
The petitioners are directed to appear before the Elaka Magistrate stroke jurisdictional court within 15 days and apply for bail, which may be considered by the court in accordance with law. Till then, no coercive action to be taken.
Yes.
Have earlier interim granted lordship 482 application. FR is on page 8. Lordship, petitioner is the homeowner lordship.
Now, what do you have?
Lordship, he is on interim
Hmm.
and his statements are accurate. But I have not found lordship the injury report.
Injury report.
Otherwise, his statements are there.
Okay. It will order dated 19/3/2025. Paragraph 1, PK Das, no?
PK Das lordship.
Paragraph 2. Paragraph 3 to Nilikibate. Paragraph 4. Paragraph 5. Third learned additional PP, Mr. KK Das. So stop. I have considered the, I have also scrutinized the case diary. The petitioner has appeared before the IO and has cooperated with the investigation. Stop. His statement has been recorded. The petitioner has not violated any bail conditions. Considering all aspects, the interim order dated 19/3/2025 is hereby made absolute under the same terms and conditions. Sent back the CD.
Okay, it's stated here that in the medical report, the person who has examined lordship is on earned leave. That is well, on 52 up to 15/5/2025.
Because he sustained grievous injuries.
Okay.
That is why he is on earned leave.
Obliged.
Is
Yeah,
it
please,
concluded?
lordship. I am
No.
taking cancellation of an offence.
Orders.
My lord, I am for respondent, my lord. Cancellation for bail, my lord. They have filed.
What is this?
My lord, this petition is filed by the petitioner, my lord, IO, my lord, for cancellation of
Cancellation of bail.
bail, my lord. A long pending case, my lord. They have taken two grounds, my lord, that I did not cooperate with the investigation, my lord. But when my interim order was absolute, my lord, there is an
You have
observation.
the CD?
Is there lordship? I have not gone through lordship.
Don't really give you some time.
Lordship.
Today, tomorrow, day after
Tomorrow lordship.
tomorrow.
Tomorrow or day after tomorrow lordship.
Day after tomorrow is Saturday.
Oh, Saturday lordship.
Monday?
Then Monday.
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 More effectively, below D.
Obliged. Yes.
To Harry, learned additional PP, Mr. KK Das has submitted for time to go through the CD. List the matter on.
Mid your lordship. This is the second time bail application lordship. The petitioner is behind in the bar since 27/3/25 lordship. That is 31 days lordship. And the FIR is lordship
32.
32 lordship.
Oh.
Lordship, the FIR is page number 35 lordship. The relevant portion will be lordship at page number 38 lordship. 38, the next page 39. The complaint is lodged by the sister-in-law of the petitioner lordship. May I read the FIR?
Page number 35.
39 lordship.
39, okay.
The relevant portion starts
Yes,
from
yes.
39.
Yes, please read.
So, with due respect, we mostly humbly beg to state as under, I'm Srimati Rupa Rajpur Das, wife of Dadur Das as resident Postgaon, Ward number 2, PA so and so, District Biswanath,
Assam filing this complaint against the below noted accused person who have illegally grabbed my deceased husband's land and subjected him to mental torture, ultimately drove him to commit suicide on 27/2/25. The below scheduled land in question was lawfully property of my deceased husband, Dulal Das, and he had right, title, and interest over it and was possessing and enjoying the title land as true and lawful owner. That on 23/2/25, my husband came to know some person illegally entered the trespass and grabbed my husband's land on 25/2/27. Reached the plot of land along with his brother Partha and found that those people were constructing kacha house. And when my husband and his brother asked those person as to why they were constructing house on his land, then the accused person threatened my husband and his brother with dao, lathis, etc. and chased them away, saying that তোৰ ভতিজা জোনমণিয়ে আমাক বহিবলৈ দিছে, গতিকে তই একো কৰিব নোৱাৰ, যি কৰ কৰিবি, and বেছিকে আহিলে মাৰি পেলাম. That it is mentioned here that my nephew Junmani Das is a belligerent and broker for which there are several cases pending against him, and also deals with the illegal business of money lending and main conspiration who forcefully grabbed the my husband's land and took illegal possession and delivered the possession of the land illegally to Vishal Ghose, Anita Paul, and Ruby Goala. On 26/2/25, Junmani met my husband and threatened and physically assaulted him in middle of the road. In this respect, my husband had informed the concerned police and the district commissioner, but they did not respond to my husband's plea. That on continued harassment and treats from the accused person caused my husband extreme mental agony, directly leading him to suicide on 27/2/25. After my husband's death, I discovered that my nephew Junmani was key instigator behind this act. Junmani manipulated and pressured my husband, instigating him to take his own life. In this illegal acts of Junmani, Vishal Ghose, Anita Paul, and Ruby Gwala also helped the instigated him. That the delay in lodging the complaint was due to emotional trauma I suffered after my husband ultimately dead. Additionally, I was initially unaware of my nephew's involvement, which is I have discovered. It is therefore prayed that your good self may kindly be pleased to accept this complaint, and after due and consideration of the facts of circumstance mentioned above, to do the needful in this regard and take strict legal action against all the accused person, including my nephew, that is the present petitioner lordship, who played a major role in the land grabbing and instigating my husband to commit suicide. I further submit that the immediate investigation into the legal and occupation of the action to restore my husband rightful property, and further I seek protection from my father to its
Yes,
harassment.
yes.
Moreover, the allegations, specific allegations are there against the.
You want interim bail?
Lordship,
This is
a
motion.
motion
Let us call for the CD.
The lordship.
there, but
Instigation is directly mentioned in the FIR.
but lordship,
I understand. In the FIR, it may not come up. Or in the statements, it may not come up.
he committed suicide a month ago, and then
Yes,
this
yes,
FIR
true.
has been lost. Lordship, therefore, the direct instigation may be there, but the ingredients of the suicide, lordship, which is 108, that is not there, lordship, because he has committed
We
suicide.
need the CD because direct instigation is there from his side. And then the delay also has been explained. We'll need the CD. Call for the CD, list the matter on 8 May.
6 of May.
6, yes, 6 May.
of
Yes.
last.
May I please, Your Lordship? Lordship, here the additional affidavit has been brought into the record, Lordship. Lordship, the reason behind filing the additional affidavit is that section 48 BNSS mandate is not followed, and we have annexed the notice.
Grounds of
Lordship.
arrest.
Grounds of arrest. So
We are behind bars.
behind bar.
It is not available, lordship.
Last date CD was retained, Lordship.
What is the offense?
Lordship, it is 103, Lordship.
We'll need the CD.
Lordship, the 48 mandate is
Yes,
not
yes, it
followed,
is there.
Lordship.
How many days you are behind bars?
50 days as of today.
Let us get the CD. They will come to know. They also will have to explain
We have
whether it has been followed or not.
already supplied the service copy.
48 from the CD, they will come to know, no?
Certified copies, otherwise it is there.
Information to friends, relatives, or nominated persons.
Follow this, 48.
47 is, no, 48
Bihan Kumar, 48.
That is arrest notice of information.
relative.
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 As per Bihan Kumar Lordship, the notice to the ground of arrest must be supplied to the relative friends. or
Relatives
any
also,
person.
yes.
Otherwise, Article 22 is, the mandate of Article 22 will be violated.
And
And this
grounds
is
of arrest must be supplied to the accused also.
accused also and the relatives also. The particular judgment is clear, Article
Let
141.
me see. Which paragraph?
That's the last paragraph. Not part, but last page, last paragraph. In the Mehbubul Haq case also it was observed. We have mentioned in the affidavit. That's the last page. Followers. May I read the relevant paragraph?
Yes, yes.
The arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release, which would otherwise be available to the friends, relative, and such nominated person by way of engaging lawyer.
Which paragraph?
Lordship, the last second paragraph, Lordship, last second paragraph. Paragraph number 3, Lordship. Bihan Kumar.
Paragraph number 3.
Last second paragraph. Lordship, the last page, Lordship. The last page. In my judgment, in my copy also.
Justice Koteshwar Singh's opinion.
Opinion.
Yes, Lordship.
Opinion.
Okay.
Here, the arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release, which would otherwise be available to friends, relatives, and such nominated person by way of engaging lawyer, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the ground of arrest to the detainee and in addition to his relative as mentioned above is not merely a formality, but to enable the detained person to know the reason for his arrest, but also to provide the necessary opportunity to him through his relative, friends, or nominated person to secure his release at the earliest possible opportunity for actualizing the fundamental rights to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the ground of arrest in writing is not only to the arrested person, but also to the friends, relative, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitutional meaningful and effective, failing which such arrest may be rendered illegal.
In this case, otherwise, Lordship, eyewitness implicated and 183 statement is up to them. It is pending because of postmortem report. Lordship. So once CD will come up, Lordship, we will see, and definitely he will get, if it is not there, definitely we have to follow, Lordship.
Lordship, the law is clear. Lordship.
It is the opinion of the Justice Koteshwar. Honorable Justice Petitioner.
No, no,
No, this is
Yeah,
observation.
Ob-
Your Lordship.
Article 141 here comes. Honorable Guwahati High Court has also observed in Mehboob Haq case. Lordship. We have mentioned in the affidavit also. The relevant para is there in the affidavit. Para number 3. This is the order passed by coordinate bench.
He has taken the plea now and he has given the copy also with the affidavit. Then I'll have to grant him bail.
Okay.
He has given the affidavit also and he has taken the plea. I will have to grant him bail. Nobody has come up
Keep-
with
keep
this.
clear that,
This is the first time somebody has come up with this plea,
14.
friends and relatives, yes.
Yes, Lord.
Before this court.
Lord.
It has been
Under-
taken up in
under-
Justice P.J. Srikas court.
Lord.
But for the first time, it has been taken up in this court. Friends and relatives, all of them were
14.
pleading on 47. Now he's pleading on 48. And he has brought the affidavit also.
Lord.
I'll have to grant. Wait.
In my submission, I will press for CD. Lord. My
Yes,
submission.
it may be a murder case, but I'll have to grant bail.
Lordship.
Can't help it.
Lord.
But of course, yes, as he's behind bars since when?
6-3. 2025.
6/3/2025 in connection with so and so PS case under so and so sections. But Mr. K.K. Das, learned additional PP, Assam, who has raised serious objection against the petitioner's prayer for bail as grounds of arrest were not mentioned to the petitioner's relatives. And the petitioner has also filed an additional affidavit and has submitted a certified copy of notice
48 of the.
of notice under section 48 of the BNSS 2000
23.
grounds of arrest has been mentioned here.
Which lordship?
You are hereby informed that the following person is arrested in connection with the case and section is mentioned here.
Only section, time and other things are mentioned, but ground of arrest is not mentioned. Lordship. Ground of arrest has to be specific.
This is the ground of arrest. What else is
No,
the
Lordship,
grounds of arrest?
The ground of arrest is specified, lordship. The ground has
Communicated, it has to be understood. I know, I have read that
Lordship,
judgment
yes.
completely.
In 47, the ground of arrest is very specific there. Why I have been arrested, the reason for the what material evidence is against me. That in 47 it is mentioned. But in
Yes.
48, only the time and date and the arrested person particulars will not suffice the ground of arrest.
No, who said? It is not mentioned in the judgment. It is not
It
mentioned
is
in the
mentioned,
order.
Lordship.
No.
It is mentioned, Lordship.
No, we will have to debate that. We'll have to discuss.
Lordship, it is mentioned categorically.
No. There has to be, it has to be discussed.
Lordship, I can
There has to be a debate from the prosecution side. I'll fix a date.
produce.
This is
Lordship,
nothing
order.
but I have read the order. Grounds of arrest is, whenever the accused has understood why he is arrested, this is the grounds of arrest.
Lordship, in Pravir Purkasta also it is specifically mentioned, Lordship.
But you have not brought probate cluster here.
Lordship, we can provide with the judgment, Lordship.
Then you can come up with probate cluster there.
We have the judgment.
You have not brought probate cluster here.
We have not mentioned in our affidavit, but we have the judgment copy, Lord. The judgment is clear, Lord.
Then show me the judgment. Probate cluster.
Lordship, may kindly fix F2, Lord.
Lordship, it is on PMLA case, Lordship, and this is a murder case, Lordship.
Not on PM.
No, for
That-
Probate Purkasta is,
Not only for PMLA, but for other cases also.
when it
Lordship,
is,
No. It is mentioned in Dhyan Kumar, not in probate cluster.
Lordship.
So you will have to read both the cases. Probate Purkasta completely and Dhyan Kumar completely. So Dhyan Kumar has discussed probate Purkasta and Dhyan Kumar has finally come to the conclusion. Dhyan Kumar has finally come to the Sasid submitted.
Sasid submitted. Lordship.
You are on interim bail.
No, Lordship.
Third learned counsel, Mr. N. Ahmed,
Lordship, my name is
not
Here or
mentioned
not?
here.
My name is in charge sheet. Lordship, my name is there or not?
Sasid, I
It
don't
is-
know.
I have to do, only I have the Sasid number, Lordship, and
My name is not there.
You're not.
Why
there.
I approach the
are you sure your name is not there?
Then this petition has become infructuous.
in fact for the clarification is Lordship, my name is against my name is Sarsid or
You
not.
get
How
instructions.
many witness, accused are there in this case?
One accused arrested,
One arrested.
two
Two
accused.
arrested, okay.
You get instructions.
Lordship, I have only that instruction that Sasid submitted, Lordship. Number and date.
But you are not, you know that Sasid has not been submitted against you.
If
I know
that would-
confirm, Lordship.
Lordship, Sasid
Lordship.
submitted.
Only information Sarsid submitted.
Third
But
learned counsel, Mr. N. Ahmed for the petitioner. Learned additional people, Mr. K.K. Das has submitted that Sasid has been laid against the petitioner being CS number
11/25 dated 22/3/25.
Okay, then I'll not pass any order. Matter stands close. If you want to approach, you can approach. So as Harshit has been submitted, I have matter stands close. That much I am passing, then if you are not Harshit, then you are free.
Only clarifications by how many accused are charged against charged. On
Will you obtain the
Tuesday lordship,
clarification?
next week Tuesday lordship.
Lordship, that is very difficult because their phone number, we don't get their number because they are very busy, Lordship. We are also busy, Lordship.
Mm.
That is why.
They are also very busy. PP, they are very busy going to the CD or throughout the day.
Lordship.
Matter is closed.
Net please, your lordship.
Mm.
An anticipatory bail application, I have entered appearance today, I have filed Wakalat number today, my lord. So my name is not there in that process. My lord, your lordship will find the FIR at page 11. Case pertains to, my lord, cheating by impersonation and forgery. Lordship, it's page 11.
Mm.
Page 11. With reference to the subject cited above, I have the honor to report that as per the above reference GD entry number, today on so and so date, I received credible secret information from the additional SP headquarters so and so, stating that one Zamir Hussain of such and such village is engaged in the making of fake PAN cards, and there is a need to investigate the matter on the ground. Based on the above information received, I, along with so and so police staff, proceeded to so and so place in a government vehicle bearing number so and so. Upon reaching so and so place, I, along with my staff, entered the house of Zamir Hussain. Upon questioning, he revealed that he applied for PAN cards for others online from his own house. Accordingly, a search of the house was conducted and 20 PAN cards in sealed envelopes were recovered, along with other items listed in the seizure memo. Upon further questioning about the names and addresses of the recovered PAN cards, Zamir Hussain stated that the names and addresses were fake and that he had never heard of such individuals in his locality. The names of and villages mentioned in the recovered PAN cards are as follows. 20 names are given. Later, Zamir
Which page
Hussain,
you are reading?
my lord, page 11, my lord.
No, there is nothing in page 11. The Belak case diya ho maybe? No, it 33 hai.
Sorry, my lord. Page 11. I'll just give a short of the affair, my lord. One police received information that one Zamir Hussain was forging PAN cards. So police team went and raided Zamir Hussain's house, and there they recovered 20 PAN cards. List of their names is given, and Zamir Hussain said that I do not know the names and identities of these people. I had procured the PAN cards. Now, page 12, your lordship will kindly come. There, my role comes in, my lord. That I will read, my lord. Lordship has page 12.
Yes.
After the list, my lord, number 20. Later, Zamir Hussain confessed that these names and addresses were fabricated, and these individuals did not belong to the mentioned villages. He further disclosed that his friend Sajidul Islam, I am Sajidul Islam, my lord. Sajidul Islam used to provide him with the names, photographs, and applications of the applicants with forged and fake voter ID and other fake documents. Zamir Hussain would then upload these details on the government PAN application portal using his laptop. Once generated, the PAN cards were sent via postal service to the house of Sajidul Islam in so and so place. After receiving them, Sajidul Islam dispatched the PAN cards to different locations in India, so and so place. Upon further investigation, Zamir Hussain alleged that while uploading the PAN card applications, he was required to attach an Annexure A form signed by a gazetted officer. However, these documents were forged by the stamp of IC Superintendent of Secretary of JK Arabic College, Jordanga. He admitted that he himself affixed this forged stamp on the annexure forms before uploading the applications. The counterfeit stamp and stamp pad were also recovered from his possession. So Zamir Hussain was the forger. I was the one who provided him the details of these persons, in whose name this forge comes. And subsequently, Zamir Hussain gave me the PAN cards, which I dispatched. So my role is providing the information and subsequently, after collecting the PAN card, dispatching it. Now, that is the allegation now. Subject to now the contents of the case diary, because that will reveal if my role is there and my detention is required or not.
Regarding this, first I want to emphasize on the seizure list. According to the seizure list, Lordship, in the house search, Lordship, this accused person's house search, there are one Aadhaar card in the name of Supita Yazum and 11 numbers of EcoBank passbooks in the name of different persons, Lordship, is there. However, Lordship, these are the documents which are needed for PAN card documents, Lordship. Verification is there for PAN card document preparations. Again, if I go to the statement of this co-accused, he has stated that he provided, as my learned friend has already stated that he has provided this number, this documents, fit document. He also don't know. He uploaded it. And again, when these documents were ready, and it was gone to the address of this person, Lordship, and it is in the name of Iron Shop House. It is his shop, Lordship. So, prima facie materials are there, Lord.
So, my lord, that is my case, my subject to contents of the case there, because allegation otherwise.
Let me see.
Lord.
This allegation is very serious. He is the owner of the Iron Shop House.
Shop house. That is the address in which Zamir Hussain sent the PAN cards. So my role is that, my lord. That is also there in the FIR, and that is also what this person has, Zamir Hussain, has stated.
I don't think so. He deserves anticipatory bail.
Anticipatory bail, ma'am. Only thing is, these are all offences punishable up to 7 years.
If he's
Perhaps.
arrested, then you come up with grounds of arrest.
Grounds of- No, no, no. Now police have become wiser, my lord. Now in these new cases I have seen, my lord, the forwarding report, they are pasting that forwarding report in the notice. So this plea is very difficult.
They are forward report.
Now in the forwarding report, because they are typing it nowadays, that same forwarding report in the notice, they are now.
Lordship, I apologize. I have a.
Yes,
report,
please,
Lordship.
please.
The grounds of arrest, in new cases, it will not be possible.
Hmm.
Now with directorate of prosecution is also there, my lord. So
Hmm.
they are ensuring that. Materials are there, my lord. I cannot dispute that part, my lord. The only thing is whether custodial detention will be necessary or not. Otherwise, I'm willing to cooperate, my lord.
Come back and it will take some time.
My lord.
I'll come back and pass the order.
Hello. Sir, I have a matter fixed at 2, my learned friend will be here. my lord.
আরম্ভ করেছিল নাকি না করা না Our learned counsel, Mr. A.S. Nawaz, for the petitioner. Sajidul Islam, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. K.K. Das, learned additional PP Assam. The learned additional PP has raised serious objection against the bail petition, stating that there are incriminating materials in the case diary against the petitioner. The petitioner is deeply involved in the offense and he is the owner of the shop. Full stop. The FIR unfolds that and information was received that Zamir Hussain is engaged in making fake PAN cards and in manufacturing fake PAN cards. And the investigating team went to his house. So on being confronted, Zamir Hussain admitted that he applied for PAN cards for several applied for several PAN cards online from his own house. Full stop. On raiding his house, 20 PAN cards in sealed envelopes were recovered, along with other items mentioned in the seizure memo. Full stop. The names and addresses of the individuals on the 20 PAN cards were fake as admitted by Zamir Hussain. full stop. He further disclosed that the present petitioner used to provide the names and addresses along with photographs of the individuals, which were then forged and the PAN cards were manufactured. So thereafter, Jamil Hussain would upload these details on the government PAN application portal using his laptop. So after uploading the same, the PAN cards were sent via postal service to the house of the present petitioner, and the petitioner would dispatch the PAN cards to different locations according India, in different locations across India, across India. Full stop. The shipments were made under the name of Ion Mobile Shop, owned by the present petitioner at Thakubari. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the present petitioner. The petitioner is involved in an economic offense. And this network is spread throughout India. And this network reaches throughout different states of India. It appears that investigation may be adversely affected if the petitioner is insulated by an order of pre-arrest bail. At this juncture, I am not inclined to grant bail to the petitioner. Considering all aspects, petition stands reject. Economic offense are like serious offense. Petition with prayer for pre-arrest bail stands rejected at this stage. Send back the CD. আৰু এটা সেই সেইটো বাকি আছে ন কোনবা কৈছিলে যে আৰু এটা যে কৈ আছিলে 2টা বজাত কম বুলি এইটোৱে নেকি না এইটোতো এইটোৱে আৰু এটা কৈছিলে 2টা বজাত কম বুলি yes
May I please, Your Lordship? Lordship, the question before this honorable court regarding the 48 notice, Lordship.
And that judgment is there.
Yes, judgment is.
I am saying that grounds of arrest has been mentioned.
Yes, that has been made clear in the probable forecaster judgment, Lordship. Lordship, may I submit this? Lordship, here what ground of arrest
Here,
is?
see, this probable forecaster judgment was discussed in Bihan Kumar.
Yes.
Then Pangas Bansal judgment was also discussed.
Yes.
And then finally it is stated that grounds of arrest has to be communicated.
Yes.
It's not necessary to be written.
In writing,
Yeah.
it is necessary. It is.
Probable forecaster has stated, but here it's not stated.
Bihan Kumar also stated.
Last paragraph.
Last paragraph.
Yes. But see, there are conflicting decisions between two judges. It will